are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5159, Campaign Legal Center Appellants versus Federal Election Commission. Mr. Gaber for the appellant, Ms. Holman for the appellee.
Mr. Gaber, good morning.
Good morning. May it please the court. Mark Gaber for appellants. Congress conferred upon CLC a right to timely agency action on its administrative complaint filed with the FEC. And Congress and the FEC have conferred upon CLC the right to receive information upon the adjudication of CLC's administrative complaint. By failing to act for over 4 years, the FEC has denied both rights to CLC. And these injuries fall squarely within this court's precedent, recognizing plaintiffs have standing to pursue their statutory rights to information, and in this case, to the right to timely agency action. And this has been true across a number of contexts. In the Sunshine Act case, the Rushforth case, this court recognized and reaffirmed in the Zivotofsky case that a plaintiff has standing to pursue a statutory right conferred by Congress to remedy that harm. In the FOIA cases, this court has recognized that Congress can confer a right, in that case to information, recognized by the Supreme Court in Akins and the FEC context in particular. And that standing exists regardless, without asking the question of what separate harm has the plaintiff experienced. This court has reaffirmed that recently in the McGann case, and again in the recent Maloney versus Murphy case, has spoken to the particularized type of injury that one has when Congress gives to an individual, in the case of Murphy, certain members of Congress, the right to sue that it does not bestow upon others who may have brought that claim if they so chose. The FEC and the amici focus on the common cause case, but in common cause, the only issue before this court was whether the plaintiff had standing to challenge the dismissal of their claim. And although the statutory provision that gives CLC the right to sue here it's one statute, it's one provision, it's a long paragraph with a series of sentences, there's two distinct causes of action in that provision. And there's two distinct types of harm that a plaintiff might have under that provision. And so in common cause, the court was only presented with a dismissal, a question about whether a dismissal was appropriate. And there, the harm is whether or not the substantive area of FEC law harms the plaintiff. Here, this is a very different context, and the harm is whether the delay in acting has harmed, and in this context, there's also the informational harm that we've pointed out in our brief. And
you didn't argue informational harm in your complaint or below.
Your Honor, the informational aspect is brought up in the complaint in paragraph 3. CLC's informational, the fact that CLC uses information to do public education campaigns, to inform voters of illegal contributions. And I would note that the FEC has not challenged the CLC's raising of the informational harm on appeal.
Well, we have an independent obligation to determine whether you have standing. Doesn't matter whether the FEC raises it or not.
That's right, Your Honor. And I would say that in this case, this is a legal argument. The law gives CLC the right to information, including the Federal Register official policy of the FEC lists a bulleted.
But you still have to assert a claim. What paragraph did you say your complaint makes this claim?
Well, in paragraph 3, which is the kind of general paragraph that discusses the parties, it talks about CLC's, what CLC does, the fact that CLC engages in public education, And this legal argument is directly related to...
But that's not a claim. Just saying that you collect information isn't a claim. That's not asserting a claim of informational injury.
Well, the claim, Your Honor, is the delay in acting, and by delaying, the FEC has denied CLC access to the information. There isn't this isn't.
So your claim is based on delay. Your claim is not that you have been denied information. Your claim is that you were entitled to a decision or action within a certain period of time and you didn't get it. That's your claim. And that's the claim that the district court analyzed, and that's the claim that the district court found was wanting.
And there's two types of harm that claim. And so because FECA prevents a plaintiff or any person from accessing this information until the administrative complaint is adjudicated and a decision is announced, CLC couldn't bring, for example, a FOIA claim here seeking this information. The only way CLC can get this information is if its complaint is adjudicated. And so the only claim CLC could make here is a delay claim. But the harm that flows from that delay is both the denial of the right to timely agency action, which is an independent statutory right that Congress has conferred that confers standing here, and also the fact that by using a delay, the FEC can permanently deny access to this information, and in so doing, prevent CLC from being able to bring a separate claim under FOIA because the FECA requires the information to remain confidential until the administrative complaint is adjudicated. And so,
on your delay claim, there are just a lot of federal statutes that say people who are aggrieved by agency action can bring a lawsuit. That's a lot of cause of action provisions. What about this statute makes that cause of action provision, that reference to being aggrieved, create a legal right in a way that wouldn't do so for, I can't imagine how many other statutes. What I'm asking you is, how could we write an opinion in your favor that would distinguish every other statute that uses similar language?
2 points, Your Honor. The first is that when Congress uses that phrase, aggrieved, the Supreme Court said that should be casting the standing net widely. The second is that FECA, unlike I think most other statutes, actually provides some indication of what Congress thinks is the appropriate time period upon which to measure that delay. And that's different than most other statutes that do not do that. That for the APA, for example, has a more generalized provision. Here, Congress, in an area where it has...
If you agree that's not a time limit for action, it's just a measurement for sort of a baseline to start evaluating their conduct. So I don't know how something that's not even a real time limit can be critical to creating a legal right just to action by the agency.
So I agree that it's the...
Sorry, and the legal injury, when I say legal right, I meant legal right and legal injury just by the inaction.
So I think it's more than just a jurisdictional, it's not just, you can file a lawsuit at 120 days. It is that. But in some cases, Congress has given an indication of what it thinks in some cases may be an unlawful delay. In some cases, it'll be 120 days. In other cases, it'll be longer than that.
Is your position that every single time they use the word aggrieved and then have a time frame for anticipated agency action in every one of those statutes in the U.S. Code, those folks are legally injured for Article 3 standing purposes to file suit just because they asked for agency action and it didn't happen within that non-limiting time period?
No, Your Honor. I think that it's context specific, and with respect to FICA, Congress was clear that part of the substantive importance of the statute is that responses happen quickly, and otherwise you can totally subvert the purpose of the statute. And two,
there's lots of statutes where Congress wants agencies to act quickly, particularly if health and human welfare are at stake. So I'm not sure that is much of a distinction. I'm not sure how one could write an opinion on your delay claim that would find standing in a way that's not going to open the doors pretty broadly. That's what I'm trying to get. So the fact that Congress put that, I mean, the only indication we have that they wanted them to act quickly is that time frame. So it's kind of bootstrapping to say that that's a difference.
I'm red lights are flashing. I mean, may I answer?
Please.
Go ahead. Yeah.
Thank you. I think an important thing that distinguishes this case from those other statutes is this informational component that goes along with the delay, that is a right granted by statute. And
I think anytime an agency doesn't act, someone could say, well, if they did act, I would have whatever information is created by their action.
But I think this court's precedent in the PETA case and in the anti-vivisection case makes this a stronger case for standing, that there is unlike in PETA where there was no statutory right to file a complaint and there was no statutory right to the information. It was just information that the USCA was voluntarily giving. Here, Congress has set up a complaint process and given a right to timely action in that complaint process, and has, by statute, by regulation, and in the Federal Register, set out information that you must receive.
But the problem is that you never said in your complaint anywhere that there was specific information that you hadn't received, that if you had gotten it, you would do something with, or that is harming you in any particular way because you haven't received that information.
And Your Honor, I think that the FEC has challenged the standing sort of facially and not factually, and I think recognizes that there is this obligation to provide this information. And to the extent there is a pleading issue on that score, I would submit that the proper course would be to grant leave to add that allegation, which I believe elevates, sort of a form and not a substance issue.
Was it a form? I mean, can you tell me a case where this court has granted leave to amend or ordered the district court to grant leave to amend when you never asked the district court first?
Off the top of my head, no, Your Honor. But I would point out that this court has recognized that CLC uses this information in cases, where CLC is the party, and that this is
CLC has alleged informational injury.
Correct, and this is not an issue that either the amicus or the FEC have raised, and I would say they have waived it.
All right, if there are no more questions, we'll give you a couple minutes in reply. Ms. Holman. Ms. Holman.
May it please the court. My name is Elise Holman, and I represent the Federal Election Commission in this matter. The sole issue on appeal is whether appellants have standing to file suit against the FEC for its alleged failure to act on an administrative complaint. According to this court's decision in Common Cause v. FEC, the answer to that question is a resounding no. In Common Cause, this court held that Section 30109A8A of the Federal Election Campaign Act creates a procedural right to sue, not standing. And the court further held that plaintiffs do not suffer informational injury if the information being withheld is simply the fact that a violation of FICA has occurred. Common Cause effectively forecloses standing in this matter because appellants have failed to distinguish their two alleged injuries from Common Cause's clear holdings. First, contrary to appellant's argument,
how would this statute ever be enforced if the FEC could simply just not act on anything that's filed?
Your Honor, it would be enforced if the plaintiffs actually first established that they had standing. It's not
no, but
that
for people who are filing complaints, I don't know what kind of standing. If you're not actually sort of someone running against somebody, the competitor, and it's not the type of claim that we had in Akins, where even voters could say they need that information. Or in a case like this, who could ever sue if the FEC said, we just don't feel like doing this part of our job? I'm not saying this would happen here.
Your Honor,
the FEC just said that we don't want to deal with this stuff. There's no, I don't know what injury anyone's ever going to have in this context.
Your Honor, you are correct that the plaintiffs in Akins would have standing in this circumstance. If a complainant had alleged that there were some non-disclosure, whether non-disclosure of a contribution or an expenditure, some sort of non-disclosure related to their underlying claim of an alleged FECA violation, then they could establish informational injury that could be sufficient for standing.
But
however,
how people know, how can they know what's an unknown disclosure or an unknown contribution? How can people know an unknown contribution?
Your Honor, I believe that.
Right, if it's undisclosed.
I'm sorry.
You said that was your answer, right? If it's undisclosed, then they can sue. But of course, if it's undisclosed, members of the public aren't going to know about it. That's the whole point of not disclosing it.
Your Honor, often there are enforcement and administrative complaints filed claiming that disclosures were not properly reported. And it would be a similar situation here. If they allege that there was, I'm sorry?
No, so if people just proudly announce their violations of the law, hypothetically, let's not talk about this case because we're not anywhere near a merit stage. But if, let's say someone is just sort of flagrantly making contributions in violation of the law to a PAC, they realized from this case that as long as they disclose them, they actually can't be stopped. And the FEC is like, we're not going to bother with these things. The statute just, Congress intended to just, the FEC just, there'd be no enforcement of these problems?
Well, Your Honor, I believe that what you're getting at, if they understand that, or if they know that a contribution has been made and that contribution they allege violates FECA, and they bring a claim, but they don't disclose or they don't allege that they've suffered informational injury, then essentially their interest that they are asserting is an interest in enforcement of the law, which is not a legally cognizable interest that is sufficient to create standing.
Well, what if their interest was, it's very hard for our members to participate in a voting system in which all of these illegal contributions are happening. If someone said we have members and they're now incentivized to vote because of this sort of pollution of the electoral system. And to be clear, I'm talking about a hypothetical case. Would that be sufficient to have standing?
Your Honor, I'm sorry. I don't think I heard all of your question. Right. I apologize.
If an organization sued and said our members are disincentivized to participate in the electoral system, they're turned off because there's all this corrupt money being donated, and they cite a particular instance, like was done here. They find sort of something that they believe was improper, and they say it happened 3 times, and this so colors their faith in the electoral system. They're no longer interested in voting or participating because it's not being policed the way it's supposed to be. Would that be a sufficient Article 3 injury?
No, Your Honor, I do not believe that it would, because Section 30109 A8A creates a procedural right to sue. The complainants need to allege a harm to a substantive right. And I'm not sure that in that context, they will have made a sufficient argument that a substantive right has been harmed.
So the statute doesn't create a substantive right to a fairer or to an electoral system in which these types of unlawful donations aren't made?
Your Honor, Section 30109 does not create a substantive right. It creates a procedural right to sue.
It doesn't. Your injury doesn't have to be in the enforcement provision. Does the statute, does FECA, protect the rights of voters to?
Yes, Your Honor, absolutely.
An electoral system that's not polluted by what the statute defines as improper donations.
Your Honor, I agree that that is the purpose of the Federal Election Campaign Act, to maintain integrity of the electoral system and to maintain the faith of the voters in the electoral system. Yes. But given that this is a procedural, section, in order to claim a violation of Section 30109 A8A, they need to allege a substantive harm, which they have failed to do in this context. Section 30109.
Your argument on informational standing focused on, as you said, they already have whatever information they might need. But you don't otherwise contest their standing to assert an informational standing case? That they have, you don't seem to contest that they haven't asserted an informational injury, and I'm curious about that.
No, Your Honor, they haven't alleged an informational injury. As Your Honors were discussing earlier.
Why does your brief argue the merits of whether there's an informational injury as opposed to whether they've even alleged one at all?
Your Honor, our brief worked off of the assumption that perhaps their complaint sufficiently saved the informational argument. However, I agree that it absolutely did not explicitly allege informational injury. And they certainly, at the district court level, did not rely on an allegation that they were entitled to FEC investigatory materials. Mm-hmm. But assuming that they had sufficiently alleged an informational injury, we engaged in a discussion of whether that injury was actually sufficient for Article 3, and it is not.
In their situation, so whether them or someone else came forward and had identified a distinct, concrete, particularized injury from these unlawful donations. And the FEC found probable cause, went forward. What kind of documents would be created through that investigative process and the voting process by the commissioners? What kind of publicly available or publicly disclosable documents?
Of course, Your Honor. Well, the documents cannot be disclosed until the resolution of the matter because FECA prohibits any information being disclosed while it's pending. But upon the resolution, the FEC releases the basis of its determinations and has a policy of generally releasing documents such as the General Counsel's report, briefs, memos, votes, reasons to believe, and similar sorts of documents in order to satisfy the regulations requirements of supplying the basis thereof.
Okay, thank you.
Of course. Your Honors, neither of appellants' alleged injuries amount to injury in fact. The section does not create a substantive right to FEC action within a specified time frame, and they have not alleged. Your Honors, I see that I have run out of time. May I briefly conclude?
Yes, go ahead.
Thank you. They have not sufficiently alleged informational injury because they've not been denied any of the information that FECA requires to be disclosed at this time. And the additional information that they seek are legal determinations that they are not entitled to. And because they have failed to establish injury, they have not demonstrated standing. And we would respectfully request that this court affirm the district court's dismissal of appellant's complaint for lack of standing. Thank you.
Judge Henderson, are you there? And is Judge Henderson there?
Judge Millett, we do have a connection, and Judge Henderson is unmuted. I am not sure why we cannot hear her. I'm going to figure that out with IT.
Okay. Do you want to go ahead and just take 2 minutes, Mr. Gaber, and we'll have this recorded for Judge Henderson. And,
Sure.
and then we should take a break before we start the next case.
2 points in rebuttal, Your Honors. I'll start with where counsel left off. I do not think it's the case, and this court's precedent do not make it the case, that the only type of informational harm could be a reporting or disclosure violation. In the Friends of Animals case, the informational harm under the Endangered Species Act was the information sent along by the participants in the agency proceedings. And here, under the FEC's policy in the Federal Register, we would be entitled to the respondents' responses and any information in the FEC's discovery that they produced. And that's similar in the PETA case with the Animal Welfare Act, that it's investigatory information that's provided that there's an entitlement to. And so to cabin informational standing in this case to just the reporting and disclosure substantive FECA violation would set a different precedent under FECA than exists in any of this case, any of this court's precedent. And second, on the claim that this is just a mere procedural right, in Spokio, the Supreme Court said that the reason that some procedural rights will not confer standing is that there might not be any harm that flows from for example, from incorrect zip code in the Fair Credit Reporting Act context. Here, there's always harm that flows from the agency delay because one, for the substantive enforcement of FECA and CLC's ability to educate people to decide whether or not they need to make a rulemaking if FEC is not interpreting the law correctly. We'll never know the FEC's interpretation if they never act and can't engage in any of those activities. But we will also never receive the information we're entitled to, but can't make a claim about until the agency acts.
Judge Henderson, are you back on? Judge Wilkins,
we're trying to solve this issue.
Okay, now it's solid. The red light is solid.
Apologies for technology.
Well,
Judge Henderson, this is Anne, the courtroom deputy. Can you hear us?
hello? Hello?
Judge Henderson, we can hear you now. Can you hear us?
All right, well, why don't you tell Judge Millett, or tell Ann to call the next case, and you and I can talk.
All right, I just heard this, and I will now call the next case. Thank you very much.
The case is submitted.
Thank you, Judge Millett.
All right. I don't know what to do. I will tell you this little thing in the middle of the headphones. It's a little circular thing. It has a minus and a plus, and there's a red light. And right now, and it was blinking, so I hit it.
Judge Millett, would you like me to call the next case?
Are we waiting for Judge Henderson, or? If not, then we should make sure she's muted because I hear her talking sometimes. And if she's not aware, she's on.
I have just muted Judge Henderson, and I also sent her a request to unmute. Judge Henderson, are you back with us? Can you hear us? Judge Henderson, this is Anne, the courtroom deputy. Are you able to hear us now? Judge Millett, did you want me to call
It
a
said
recess?
unmute, and so I hit unmute.
And can we take a 5-minute recess and try and see if we can sort this out? And if not, then we'll proceed so we don't stop everything.
You all can't, they can't
Absolutely.
hear me.
This
Now I
honorable
can't-
court
now
will
I
now
can't
take a
hear
brief
them
recess. What this means for the attorneys and the law clerks, I will now put you back in the waiting room and I will bring you back in when we're ready to start again. I am pausing the recording and just give me a few minutes so I can put everybody back in the waiting room.
Bottom left, mute, yes, hit it,
Let me mute Judge Henderson.
all right.
Judge Henderson, may I call the second case?
Yes, please.
Case number 20-7017 et al. Lusik Usoyan et al. Versus Republic of Turkey appellants. Mr. Schammel for the appellant, Ms. Frischman for the appellees.
Mr. Schammel, please begin. Before you do, I apologize to everyone. I don't know what I did, but I'm back on, so please proceed.
That's wonderful, Your Honor. I'm sure I would have not been able to figure it out either. May it please the court. Good morning. My name is Mark Schammel, and I'm here on behalf of the appellant, the Republic of Turkey. The district court erred in its Prong 2 analysis of Berkowitz when it denied Turkey's motion to dismiss. The Berkowitz test is a clear analytical vehicle for a dispassionate analysis of a foreign sovereign immunity claim. The court need not engage in any factual analysis of degree or nature of force, nor should the district court do any balancing of the alleged facts, as was done here. To do so is to get into the exact second guessing that Congress intentionally sought to avoid when it passed the statute, and that the Supreme Court found in Gobert. 28 USC.
It's before Mr. Erdogan, President Erdogan's car had even arrived at the residence, before it even arrived at the residence. The security agents knew it was en route. And one of the agents pulls out a machine gun and shoots every single protester because they fear they're terrorists or terrorist supporters, and they want to make the place secure for the president. Could there be a lawsuit for that?
The answer, Your Honor, is it depends.
Okay, tell me why it depends. I'd really like to know whether you think there could be a lawsuit, whether there would be discretionary function immunity in that context or not. So tell me what it depends on. What more facts do you need?
Well, I think the starting point for such an analysis, Your Honor, for any district court is to determine what is the conduct.
I've just described to you what the conduct is.
And if the
I'm
conduct
going on my hypothetical, not this case. I'd just like an answer to that hypothetical.
Correct. And in that hypothetical, if it's assassination, that may be a horse of a different color.
Well, how do I know if that's assassination? I've given you the description. I've given you exactly the facts we have. Assassination will be someone's label or not. What we do know is a machine gun was taken out and all the protesters were killed.
And
before the car arrived.
I don't think that the car's arrival is necessarily an important analysis for the court to undertake, because the security function of the presidential security detail, it starts.
Okay, but I'm just telling you my facts. So under my facts, the president's not even on site yet. So you say that doesn't matter, but go ahead.
And under the court has to, under Berkowitz, start with the Prong 1 analysis, which is.
What is the Prong 1 answer to that? I know how to do the analysis. I'm just I would like to get your answer on each prong of that analysis. On Prong 1, what is your answer?
I believe on Prong 1 in that situation, Your Honor, it sounds like it's potentially a use Coggins, I apologize, I garbled that, but it's more likely discretionary function. It's a discretionary function.
What is your position? I mean, all you're doing is saying someone might argue, you're saying someone might argue that it's a violation of international law or crimes against humanity, but you would still argue that it falls within the discretionary exception. Is that function exception? Is that what you just said? Prong 1?
Yes, Your Honor. I believe.
And what about Prong 2?
Well, it's susceptible to policy analysis. Once we've crossed the Rubicon on Prong 1, now we're into, and it has to do with national security, and this is a presidential security detail acting in their presidential security capacity, then yes, it would be under Prong 2, it would be susceptible to policy analysis, and under the facts, as Your Honor has laid out, I believe. It sounds
to me like you're arguing for just absolute immunity for foreign security details.
No, Your Honor.
No, unless if they announce that they're assassinating someone, they don't get it. Is that the only exception?
No, Your Honor. I don't believe another exception.
Give me another example of when, in your view, either Prong 1 or Prong 2 would not be satisfied if you have a presidential security detail. And I'm going to say the president is in the area, whether he's right there or en route.
And I think if the president is en route or in the area, and they are, as they have been alleged in this case, acting in their role as presidential security, then the immunity is going to be very, very hard to overcome.
I would really like to know what your very, very hard exception. I'm really what I'm lost from in the briefing in this case is what would have been something that what actions could a foreign security detail take? And I'm assuming the president is here in the area, so you wouldn't say if they did it 2 weeks before he arrived. He's here in the area. He's at the White House, but getting ready to come. Is there any action that they could take against American civilians that would not fall within discretionary function?
I think that the courts have laid out the actions that would fall outside the realm of discretionary function. Things such as assassination, things that are against international law, things that have to do with espionage. Some of those would fall outside. If it was a private act, so just because one is a presidential security detail member, they're not given free rein to do anything, anywhere, in any context. But here,
why would the law make a, no one's talking about private acts, but what's the difference between assassination and just murder of civilians?
It's a public policy question, and it's also a issue of assassination is against international law, correct? And so murder in that context is really an extension of what plaintiffs have alleged here.
Murder of innocent civilians not contrary to international law?
No, it could be, but it really depends on the discretionary function of the actors. And so just because...
So is murder by security details of innocent civilians? I'm not, the hypothetical is there's no provocation.
And my view on that is the murder, which would be the death of those protesters that you're referring to as innocent civilians, is just the next level of tort that is alleged here. And that doesn't change the analysis.
So suppose the facts were as they are in this case, with one change. The protective detail members raped one of the protesters across the street when they crossed the street. Is that also protected by immunity?
I think the answer to that, Judge Wilkins, is no. And I think the reason of that is the initial threshold analysis is what's the conduct? And here, the conduct is not, as the court found below, presidential security. There's no part of raping someone that is presidential security. And so as a threshold matter, it's not presidential security, so you don't have to get into the two-prong analysis of Berkovitz.
Go ahead, Judge Wilkins.
So mowing them down with a machine gun is protected by immunity, but raping them would not be.
I think that's right, Judge Wilkins. I think that mowing them down by a machine gun could be part of presidential security.
Let me ask a question. Let me ask a question that's closer to what I think would be the facts of this case if we let it proceed. And in discovery, it is alleged that President Erdogan, and we've all watched the video, that there's a conversation between him and some of his guards. If he said, I don't want to see these people when I come back out. Do we proceed with this case?
No, Judge Henderson, we do not. Because once we've determined, and I would argue that the facts here are not very much in dispute because of those videos. Once we have determined that this is presidential security and it's discretionary, we've, as the court below found, we have satisfied Berkovitz Prong 1 for presidential security, for discretionary acts, and then the second part is it susceptible to policy analysis?
All right, let me ask you this. Does it make a difference if it was not President Erdogan who gave the order to surge, but one of the top people in the presidential security team.
No, Judge Henderson, I do not believe it does make a difference. And the reason is internationally protected persons, there's a large sort of group of people that fall in that rubric. Obviously, the president of the sovereign nation is the top, is the tip of the spear, as it were. But there was an ambassador there. There were other members of the ambassadorial staff. There are other supervisors. It all still falls within that same rubric of presidential security, susceptible to discretion. And each time a question like this comes up, I have to go back, I think, to the language of 1605A5A, which ends with, regardless of whether the discretion be abused.
Now, can I ask, I have a backup question on this, and it's something this is my own ignorance of how this works. Is there a federal statute or regulation that defines what the scope of authority of foreign security details are when they're in the United States, as opposed to the U.S. Secret Service?
Your Honor, I'm not aware of any manual or things that would prescribe the actions of the foreign security details. In fact, I would reference plaintiff's expert analysis. What they have submitted and what amici have submitted to the court is they don't really even claim that there is such a sort of a prescribed set of rules and regulations as it relates to United States Secret Service.
That's what I'm trying to figure out, right? It certainly seems like there's rules governing the Secret Service here. But the question is, there must be something somewhere, and maybe it's just kept confidential for reasons. The Secret Service is ultimately responsible for foreign dignitaries in this United States. And then the foreign dignitaries may bring their own details. And what I'm trying to figure out is, what is the relationship? Are they, if I'm walking by and the Secret Service says, she's no threat, she's just walking by, pushing a baby carriage. The Foreign Service detail says, we think that's a threat. The Foreign Service detail has the authority to attack American civilians walking by, or do they have to, because there's no active attack underway, are they supposed to contact the Secret Service agent there and say, we think that person's a threat? Or can they do anything they want?
There's nothing that I'm aware of, Your Honor, as it relates to sort of it's almost like a pro hoc vice of Foreign Service presidential protection to the U.S. Secret Service. And the Department of State, or the U.S. Service, that provides the security for our diplomats and our internationally protected persons, as well as assisting in the protection of other foreign nations, their internationally protected persons. There's nothing that says that you are essentially giving up your power protecting your country's president or IPP person just because we're also here. There is a code section that's referenced throughout the case below, which I think is important, which is 18 USC 112. And 18 USC 112, that is the statute that deals with the protecting of foreign dignitaries. And that's the statute.
By the Secret Service, by
Correct.
U.S. law enforcement forces. Right.
Correct.
That's what I'm trying to figure out. So could Congress pass a law that says if the vice president would feel more secure as long as there were no protesters within a quarter mile? Protesting upsets, even peaceful protesters upset the vice president of the U.S. This is a hypothetical vice president, to be clear. That hypothetical vice president says, I just feel unnerved and worried whenever I hear protesters, push them all back a quarter mile. Could Congress, in authorizing the work of the Secret Service, constitutionally pass a statute like that?
I think the answer to that is no, and there's a couple of reasons.
I agree that would violate the First Amendment. So can Congress set up a regime, or the executive branch, can either of them constitutionally set up a regime in which foreign security details can suppress speech in a way that the Secret Service cannot? Is that constitutionally permissible for either branch to allow that scheme?
I think, Your Honor, that already exists, because when we're dealing in some of the cases that are relied on by plaintiffs, we're dealing with there's a distinction between the FTCA and the FSIA as it relates to the difference between Americans and foreign sovereigns. And I see my time has exceeded, Your Honor.
Go ahead. Go ahead.
Thank you, Your Honor. I'm sorry, of course, I lost my train of thought.
We were talking, the question was, if Congress cannot authorize the Secret Service to enforce security in a manner that violates, we'll say the First Amendment here. There might be other violations too, but we'll just go with the First Amendment against peaceful protesters. And then and you said no, we all agreed no, we can't do that. The next question is, can either Congress through 112 or some other statute, or the executive branch through regulations or practices and policies, authorize foreign security details to suppress speech in a way that they themselves cannot?
And I appreciate Your Honor restating the question for me. And I think the answer is if they had to, but I don't believe they have to.
Hang on. I don't know what you mean by they had to. My question's very straightforward. I think it's a yes or no constitutional question. So Congress cannot pass a law that provides for security in terms that violate the First Amendment. And the United States branch could not adopt regulations that would violate the First Amendment. And so the question is, can either Congress or the executive branch allow foreign security details to take measures that would violate the First Amendment if done by the Secret Service?
And the answer, Your Honor, is that Congress has already done so.
Please point me to the statute where Congress says that foreign security details can violate the First Amendment.
It said, if you give me a moment, I can, Your Honor, because what the courts have said and what the Congress has said is that because they are foreign sovereigns, they are not bound by the same restrictions to follow the United States Constitution, and in this case, DC law, as Americans are. And so Congress has already, with the Foreign Sovereign Immunity Act and with comity and all that comes before it, they have already given foreign sovereigns, and in this case, presidential security details, the opportunity and the ability to do what they need to do, even if it violates American law.
So the Foreign Sovereign Immunities Act, in your view, is that Congress can outsource constitutional violations to foreign security details? That's what it sounds like to me.
No, Your Honor.
I should have thought the FSIA would have to be interpreted in a way that would not violate the Constitution. I think the FSIA is subject to the Constitution, isn't it? I mean, the statute, Congress in enacting the FSIA is still subject to the First Amendment?
Congress is, Your Honor.
Okay, all right. And the executive branch, to the extent they're implementing policies, is subject to the First Amendment.
And the executive branch is, Your Honor.
But then your answer is that Congress and the executive, because the president signed the FSIA into law, authorized other foreign governmental actors to violate. It just had to outsource it to foreign details, the constitutional violations.
They're not authorizing it, Your Honor, but they are permitting it under foreign sovereign immunity.
All right.
Can I ask a question about Section 112? The district court said that it would assume without deciding that the protesters were in violation of Section 112 because Section 112 says that two or more people cannot congregate within 100 feet of a ambassador's residence or a consular property with the intent to harass a foreign official or official guest. So the district court said that it wouldn't matter, that didn't matter that even if the protesters were in violation of that statute, Your brief, you argue that it does matter, or at least you say that the protective detail asked them to be pushed back 100 feet. They didn't, and that kind of factored into the actions that the protective detail took. So explain to me kind of what your legal position is on Section 112 and how it's supposed to help us decide this case one way or the other.
Judge Wilkins, 112, I think, is there as a guide in some ways. Metropolitan Police Department and the Uniformed Secret Service from the Foreign Mission Branch that were in attendance at Sheridan Circle that day, they had a legal duty to enforce 112. They should have pushed back anyone that was within 100 feet of the Turkish property or the Turkish internationally protected peoples. And so they didn't do that. And in the presidential security function, which is what the district court here found below, and plaintiffs have made clear in over 150 references in their complaints and filings, is what was happening, a presidential security function. It's just one of those things that shows how the presidential security function was being carried out to get us to the Berkovitz analysis. Because the presidential security detail for Turkey, had to do, and I don't mean had in the sense that they lose discretion, but they were using their discretion to do that thing which MPD and United States Secret Service Uniform Division were not doing. That's how I think it ties in to the analysis. I don't think it's dispositive if Secret Service and MPD had done their job, or if they don't do their job, that is somehow determinative.
Can you just follow up on that? I'm sorry, Judge Wilkins?
Go ahead.
So your view is that they have, even if they didn't consider the protesters a threat, but they got out their tape measure and found out that they were within 100 feet, they were 90 feet away from the residence. Your position is that the foreign security detail has the legal authority to push them back the extra 10 feet.
Yes.
They have the authority to enforce United States law.
No, it's
That's
not. No.
They have the right to do that.
No. Well, Your Honor asked if they had the authority to push them back 10 feet, and the answer to that is yes. Do they have any law enforcement authority in the United States to enforce United States law? That answer is no.
Well, then why do they get to enforce the 100-foot line?
Because they're not enforcing the 100-foot line, Your Honor, and that's the kind of second guessing that the district court's not permitted to engage in. What they are doing is exercising their discretionary function as part of the presidential security detail, which is the bedrock of a national security interest for a foreign sovereign, and clearly subject to.
Right, but all you're doing is, you said you're just pushing them back the 10 feet required by law. You seem to think, as Judge Wilkins said, that was important. Under your theory, it's not a 100-foot line. It's just whatever they feel like the line is needed to secure their president. That's why I was curious. You seem to be, as Judge Wilkins said, relying on that 100-foot line. But it sounds like you're not.
I think the 100-foot line, Your Honor, is important for the analysis of the starting point. What is the conduct? What are they doing? And the fact that U.S. law enforcement, Secret Service, and MPD are not doing that is one of the factors that's rightly considered as the starting point. But once you get through that they are presidential security, right, and you factor that in, they have a discretionary function, which the court below found. Now we're on to prong 2, which is, in this case, susceptible to policy analysis.
Okay,
and
I'm sorry, finish your sentence.
I don't think I have anything else, Your Honor.
Sorry. I just have, if my colleagues will permit me, one more question. As to the Macaulay incident, can you please explain to me how, since the presidential limousine had long since passed, how did the security officials going up, covering her mouth, grabbing her arm, and tearing her sign up, how did that enforce security for the president? How did that make the President Erdogan safer?
And I think the answer to that question, Your Honor, is that question is second guessing the discretionary function of a presidential security detail. We have to look at the McCauley incident.
Sorry, can your security detail explain to me how that had anything to do with securing the safety of President Erdogan? If they can't even articulate it, then I don't think we're doing any second guessing. So I'd like to hear their articulation. I don't want to second guess it. I just want to hear it.
I don't believe there's a necessity of articulating the reason. First of all, all right, with all due respect, I'm not a presidential security member. I'm not trained. I've represented many in law enforcement.
Your clients here,
They are.
government of Turkey. So surely you must have asked, how is that relevant to security?
Your Honor, the question of relevance to security is there in the presidential security detail. There is a continuing course of conduct. There's, as the court below found, there's the first incident, there's the second incident. Now we're over at the ambassador at the now we've left the ambassador's house and we're over at the
yes, you have one
embassy
person where you have one person and the presidential limousine. It's like you said, you opened this by saying just sort of a private attack would not be protected. So there must have been some sense in which, if they were just acting privately, so there must be some sense in which they thought that was necessary to keep the president safe.
Well, with all due respect, Your Honor, I want to make clear, I'm not saying there was anything private that was going on that day by the presidential security.
And am I right in thinking the world's divided into either private or protecting President Erdogan for these purposes?
I think that the world is divided into either private or part of the general job of presidential security. Okay. Yes. Tell
me how the general job of presidential security, how that attack on Ms. McCauley was part of the job of making President Erdogan more secure, his presence here more secure.
And what I would start by saying, Your Honor, is number one, we don't second guess and have to ask that question because it's not a question about how does it make him more secure.
What if it was the next day and President Erdogan was at Dulles Airport? Could we second guess?
Your Honor, I'm sorry, I didn't catch the beginning of your question.
If it was the next day,
okay.
President Erdogan is already at Dulles Airport or Andrews Air Force Base, wherever he's flying out of.
Okay.
Then what? Would that still be part of it? We couldn't second guess whether that was part of the security details operations?
So President Erdogan is in New Orleans and the presidential security details at the embassy. Am I understanding correctly?
No, I said President Erdogan's at the airport flying out of Washington, D.C. He's not about to board his plane to leave Washington, D.C. I don't know if he flies into Andrews Air Force Base, if he goes in and out of Dulles. I don't know where he flew in and out of. Wherever he's flying in and out. He's at the airport. Okay? Hasn't left D.C. Hasn't boarded the plane yet.
Yes.
Is the attack on Ms. McCauley at the embassy still part of the security details operations that can't be second guessed?
Yes.
Okay. Thank you.
All right. If there are no more questions, we'll give you a couple of minutes in reply. Ms. Frischman.
May it please the court, my name is Agnieszka Frischman and I'm presenting argument today on behalf of the plaintiffs in both the Usoyan and the Kurd cases, which have been consolidated for the purposes of appeal. Every court to consider similar facts, and it hasn't come up very often that agents of a foreign state attack Americans on American soil, has come to the same conclusion, which is that the agents are not entitled to immunity for assaulting, battering American citizens, or just acting on their First Amendment rights. And anyone who has driven down Massachusetts Avenue any day of the week in Washington, D.C. can see these types of protests on either side of the street. This is a routine part of the fabric of the District of Columbia. There are people protesting perceived injustices at the South African embassy, at the Japanese embassy, at the British embassy. The district court in this case applied exactly the test that the government of Turkey asked it to apply, and it applied it correctly. It found.
But you say that the district court didn't apply it directly because you say that the first prong of Berkowitz wasn't satisfied, whereas the district court said that the first prong was satisfied, right?
The district court put aside the first prong and didn't reach a result on that. She held that she wasn't going to make a determination on it and found on the second prong. So our position is that it could be upheld. The decision can be upheld on prong one or prong two or both.
Let's just talk about prong one for a moment. Your position is that because the district court found that the protective detail committed assaults, and assaults are a violation of district law, prong one can't be satisfied, right?
Yeah, our position is that the agents of the government of Turkey cannot violate local law, that is not part of their discretion. They're obviously constrained by local law, and that as a matter of treaty obligation and practice.
So let's suppose, for the sake of this question, that the protesters were in violation of 112 because they were closer than 100 feet to, and there were more than two of them, and they were harassing foreign official. And the protective detail pushed, after requesting the U.S. law enforcement to do so, and U.S. law enforcement refusing to enforce the 100-foot boundary, they went across, and all they did, in my hypo, is they push the people back more than 100 feet because they considered the 100 being within 100 feet a threat. That's an assault, because any unconsented touching or use of force is an assault. So is that not immune? That fails the first prong of Berkowitz?
Your Honor, if it's an assault, I think it does. I think also that it's
well,
clear
would that be an assault?
That would have to be determined under DC law. If it met all of the elements of DC law, then
they push them back. They push them back 20, 30 feet, however many feet it takes to get them more than 100 feet away. That's an assault, right?
Yes, and I think, therefore, I mean, first, they're not entitled to enforce DC law. That's a matter that is up to the DC police and the Secret Service. So they would be acting outside their discretion. So under the Red Lake case, they wouldn't have immunity for that reason.
So even though Congress has specified that these people shouldn't be within 100 feet, and they feel that that's not just a violation of U.S. law, but a danger, and they push them back, they could be held liable for doing so.
I think that is very close to the fact pattern that this court considered in the Red Lake Chippewa Indian case, where the FBI, without authority, tried to enforce the law on an Indian reservation. And this court held that the FBI was not entitled to immunity for that reason, because it exceeded its own authority and enforced the law where it didn't have authority to do that. And the Second Circuit decided the same thing in the CIA mail opening case, where somebody exceeds their authority and acts to,
well, this isn't just kind of enforcing laws because you feel like, you want to take it upon yourself to enforce the law. They're trying to protect the president, the head of state. They can't do that. Those cases are analogous to this.
If we're talking about prong one, then I think DC criminal law does restrain the government of Turkey. That is in the restatement, it's in the Foreign Affairs Manual, and it's clear that that's the practice of the State Department, and that foreign agents know and are told that they have to abide by local law. And it's very clear the State Department has set out in the Foreign Affairs Manual that they will enforce criminal law, investigate, ask for waivers, and prosecute to the fullest extent of their ability.
So let's suppose one of the protesters is holding a gun, a rifle, which violates local law. And the protective detail says, go arrest that person and seize their gun. And they don't. And the protective detail goes over and tackles a person and takes away their gun. The person sues for assault, the protester, and he wins.
I think if that protester is sued for assault, they would lose for a number of reasons. But in this case, what we have the other protesters. What happened here is you had Rukin Izek, who was walking with her child in a stroller.
I'm asking you, my hypo, you say that protester loses.
If someone with a gun is threatening an agent and the agent neutralizes
them. They're not threatening, they're just holding the gun. They're holding it down by their side. And they say, arrest that person and take that gun away. And the Secret Service doesn't. And they run over and they grab the person and they knock him down and they take his gun away. Those are the facts. So that person sues and the protective detail in Turkey, they're not immune.
I think they are not immune, but they, if put on trial, would likely win on the merits.
Why?
I think they are not immune because they've exceeded their authority to act. But I think that...
So they don't have authority to knock someone down and take a gun away from them that's under 100 feet away from their head of state.
I think that is something that law enforcement here and overseas, I think, probably comes up all the time. And one of the consequences are that sometimes they're put on trial for excessive force, and the jury will make the determination of whether that conduct was reasonable and whether it exceeds, but I don't think there is immunity if it's an assault. I think in this case, it might not be an assault.
Okay.
Can I ask you, what if the same thing happens in Istanbul and our president visits, and the local authorities do not take a gun away from a protester that is near our embassy, and the Marines guarding our embassy ask the local law enforcement authorities to help, and they refuse?
I think it would be the exact same thing that we just discussed. And kind of one added wrinkle is that most foreign states have a blanket territorial tort exception to foreign sovereign immunity, and we haven't found one where there's a similar discretionary function. So that this question of discretionary function actually doesn't come up, because the states that have a territorial tort exception to immunity don't include that. So this debate wouldn't come up, but the debate of whether, I think our Secret Service are told that they have to obey local law. And I think if they don't, then there will be consequences. And presumably if their conduct is reasonable, the same thing would happen as with Judge Wilkins' hypothetical.
All right, then I'm not understanding your answer. What would happen to the Marines who left the embassy and with force either took guns away, knives away, whatever? What would happen to them in Turkey?
In Turkey, it would depend on the Turkish law on sovereign immunity. And I'm not familiar with that law, but my understanding is almost no states include a discretionary function. So if there's a tort, and if that would qualify as a tort, then they could be liable under Turkish law, but I am not an expert on Turkish law of sovereign immunity.
All right.
For purposes of the discretionary function analysis, the authority to exercise discretion has to come from somewhere. Who has to confer that discretion? Congress? Or can the executive branch through regulations? What is the source of the discretion?
The source of the discretion that the Turkish security detail is on?
Just generic, just on the discretionary. Let's start with the Federal Tort Claims Act, which gets us out of this context.
In the Federal Tort Claims Act, it would be the federal government.
What do you mean the federal? It can't be the executive branch because they're the ones getting sued. They can't get out of the FTCA just by passing regulations or policies that say we can violate state law, tort law, right?
I'm sorry, I guess I'm not totally understanding the question.
The whole point of discretionary function is that there's some discretion that has been conferred on government officials, all right? Who has to confer that discretion? Where do we look to find that conferral of discretion? Do we look to statutes?
I think you look to statutes, regulations, and policy.
Okay.
Under
what statute, regulation, or policy governs the conduct of foreign security details? What confers discretion on them?
I think the outer limits of their discretion would have to be U.S. law, federal, state, and local.
Wait, so is the question whether the Turkish government has conferred this discretion on the detail to attack protesters, or must it be conferred by U.S. law, congressional or executive?
It must be U.S. law because it's territorial. So
right.
If they're acting in the United States, it has to be U.S. law.
So I'm back to asking you the same question I asked Mr. Shamel, and that is, no one has told me where is it a statute that authorizes foreign security details to take measures against Americans when they're here is there an executive branch, a State Department regulation, a State Department policy, a State Department manual that says something somewhere must say what they can do? Because otherwise I shouldn't think they would have authority to do anything other than ask the Secret Service to take protective measures.
Well, my understanding is that under US law, and international law, the obligation to protect the visiting head of state rests with the United States, with the host country. So it rests with the Secret Service and the Department of State.
Okay.
And
what
Turkey
has they conferred on foreign security details? What role do they allot to them in this process?
There is nothing in the record that's been submitted by Turkey that indicates that they received any authorization to act in any manner. So nothing's in the record about.
So there's nothing in the record here on any law that has conferred any discretion on the Turkish security detail.
I don't believe so. And it's my understanding that under international and US law that the duty to protect the visiting head of state rests with the Secret Service, and under international law, it rests with the host country.
Can you have a discretionary function without American law in some form conferring discretion in the first place?
It's an interesting question. I suppose the answer may well be no. And there is no case, for example, that's applied the presumption to in the FSIA context. There's no way of evaluating whether or not Turkey acted in accordance with its standard operating procedures or in accordance with any regulation or in accordance with any authority that was designated either by the State Department or their own government, because there's nothing in the record on that at all in this case.
Do you know if it's worked out on a case-by-case basis before a foreign dignitary arrives, what the respective roles of their own security detail and domestic law enforcement, domestic security will be?
My understanding is that it is. That's not in the record in this case, but my understanding is that that's exactly right.
But didn't you?
Go ahead.
I'm sorry. But didn't you argue below, both through your expert's testimony and your briefing, and you argue in your briefing before us that we should look at kind of the State Department manual and procedures and what that allows and doesn't allow, and that sets the boundaries for what this Turkish protective detail are allowed to do? I mean, hasn't that been your position throughout this litigation?
Our position has been that if you go on prong one, that it's DC state law or anywhere that constrains their ability to act, that there's no ability to violate the law. And that is in the FGCA context. There are countless cases that hold that. And that's also—
Okay, let's suppose I disagree with that and we're in prong two.
Mm-hmm. In prong two, we've argued that the district court did what it was exactly supposed to do, which is it followed the instruction in Galbert to focus on the nature of the actions taken and on whether they are susceptible to policy analysis. Whereas this circuit put it in limit the nature of the actions taken rather than the status of the actors. And the district court looked at what happened, looked at the video, looked at the affidavits of arrest, the indictment, and looked at the entire record.
But what is the relevance of your expert testimony and all of the stuff in your briefing about State Department kind of manuals and procedures with respect to protection of I guess, U.S. protected persons?
Well, the relevance as to prong two is the court found that the objective conduct wasn't related to protecting the president. She found that they pushed through the police line, ran after the plaintiffs who were running away, shouted, "I'm going to rape you," and knocked women unconscious and kicked them when they were unconscious and kicked them into seizures. And she found that that objective conduct wasn't related to the presidential protection detail. I think what our expert said was the standard operating procedure for protecting a president is to take him away and not run out and attack other people, but to coalesce around the president and remove him from the danger. And that didn't happen. So our expert argued that that showed there wasn't a risk. But I think the district court's decision was grounded in the objective conduct, which is she looked at the agents of Turkey who pushed past the police line. The video is very graphic where the agents pushed past the police officers and bloodied some of their noses, ran across the street, ran at women who were running away, holding their children, shouting, "I'm going to rape you," as the woman ran across the street. And you can see her stroller capsized on the grass as she ran away when they were shouting, "I'm going to rape you, you're a whore."
So why isn't that a finding that they abused their discretion?
That is a finding that conduct is not objectively related to protect. The discretionary function never kicks in because it cuts off at that first step. That sort of conduct does not fall within the discretionary function at all, because it's not objectively related to protecting the president. It was an out-and-out attack on First Amendment protesters. So you never get to them.
We're using the language of Berkowitz. A second part of the second prong would be, this is something that Congress never intended to shield from liability. Isn't that correct?
That's correct, Your Honor.
All right.
And in fact, every court that has considered similar facts, like the Hurtado case in the Ninth Circuit and the Miango case here in the District of Columbia, has come out to the same result. In the Gerritsen versus Hurtado case, there was a man who was leafleting outside the Mexican embassy, and the staff came out, hit him with a metal pipe, and took away his leaflets. That was found not to be immune. In Miango, there was a small group of protesters that were protesting the Democratic Republic of Congo president, and his security personnel beat up the protesters and beat them to a pulp. And the district court here, the District of Columbia, held that conduct was not immune under prong one. And so we submit that either prong one or prong two, or one or the other, or both, clearly show that there's no immunity in this case, because the conduct was not objectively related to protecting the president. And I guess as an analogy, some of the cases that have been cited, for example, if you look at the forestry cases, the court can look and say the controlled burn, you could abuse your discretion to control burn, that's a discretionary function. But if the rangers had taken a gasoline can and a match and burnt down the tractor of the logging company, the court can certainly look behind the facts and say that's not a discretionary function. A controlled burn is a discretionary function, but arson is not. And that's really the same thing that happened here. Protecting the president is a discretionary function, but what happened here is like arson. It was an all-out attack on First Amendment protesters who were standing exactly where they were told to stand on the sidewalk, holding their signs. And the Lacey McCauley example is a clear example of that. This was hours later. She was chanting a pro-democracy chant outside the embassy where she was told to stand. And there's a picture in the joint appendix at 550 that shows the agents with their hands over her mouth and whipping up her signs. And the district court correctly evaluated this conduct and found it wasn't racially related to protecting the president.
So with respect to the second incident, let's suppose that the district court had found, or we believe that the evidence clearly shows that the protesters were in violation of Section 112. What relevance does that have?
I think the district court was correct that it doesn't.
Why not? Why doesn't it have any relevance?
It would be up to the Metropolitan Police Department to enforce 112 and determine if it applied. And it couldn't possibly apply to other plaintiffs who weren't within 100. We have plaintiffs who weren't near, like Mrs. Rukin was running away and outside the 100-foot point. Like the plaintiffs weren't a unified group that all knew each other. Some of them were back, some of them were forward, but all of the plaintiffs were attacked and beaten. And it certainly isn't the case that they were all within 100 feet or even knew each other or coordinated.
But as to the plaintiffs that were within 100 feet, you're saying that the fact that they were breaking federal law has no relevance to this analysis?
Well, 112 does have a carve out for First Amendment protests. So I don't think they were breaking federal law.
If we find that they were, you're saying it doesn't matter?
I think it does not impact the immunity determination.
Okay. And that's because the protective detail, if they believe that the local law enforcement is not really enforcing local law, they can't take that into account at all as to how they protect their protectee.
I think they certainly can, but what our expert said is that what would have happened in that case is you would have removed the protectee. and that the appropriate response isn't to run across the street, hit women until they fall on the ground unconscious and keep kicking them while they're lying there, or to knock people's teeth out as they're lying on the ground, and chase people across the street and shout obscenities at them while they're running away with their children. That there are certainly steps you could take within the law if you thought the MPD wasn't adequately doing its job. But one of those steps is not to commit assault on people who are standing exactly where the police told them to stand. And that's important to remember in this case. The plaintiffs were told to stand on the sidewalk by the MPD, and that's where they stood.
The second incident, there's no question that Erdogan was inside at that point, right?
I believe he arrived at his car before it started and then came out of his car and walked into the residence.
Okay, but the second one, where the surge came from the protective detail across the street, he was, you can't tell from the film, but he was nowhere outside. He'd left the car, or maybe we don't know, maybe he was still, but you had those gates and you had the fence. In other words, I'm just trying to figure out, there was no way the protective detail could say he was in danger, imminent danger, or any kind of danger for that matter.
Well, that's what the district court concluded, and I think that's what the video shows. The timestamps, I'm not sure match up quite exactly, but what seems like happened is he arrived, he was in the car, the incident started while he was in the car, he got out of the car and he walked into the residence.
Right. That's why I think there's a good likelihood he said, I don't want to see him when I come out. But okay, are there any more questions?
No.
Okay.
Thank you.
All right. Let's see. Mr. Schammel, why don't you take 2 minutes?
Thank you very much, Your Honor. I'd just like to make a couple of points, if I may, in response to arguments by appellate counsel. One statement was made, which is that there's nothing in the record submitted by Turkey, and I just would like to reiterate the burden is on the plaintiff, not on Turkey. There was a misrepresentation of the law underneath, which is that somehow foreign nationals are constrained by United States law. MacArthur says otherwise, and I think there is a clear sort of meshing in plaintiff's arguments between the FTCA and the FSIA. While similar, not in any way identical. The example given about the FBI at a Native American reservation, the CIA, those are all American actors. They are different than a foreign sovereign. It is different. The FTCA and the Plaintiff's Counsel refers to Letelier, which goes from that 1970s case in Hawaii, all talk about Americans. That's the FTCA. It's different. It's not the same.
Your point is that your point is that the foreign security detail has greater authority, whether it's to enforce DC's or enforce the statutes, the federal statutes 100-foot rule, or to allow a greater sort of curtain of protection around the foreign leader than the Secret Service, for example.
Not at all, Your Honor.
Is discretion greater than what the Secret Service has, or is it the same? What is my comparator?
The discretion is greater, but the authority, it's not a question of authority, Your Honor. They don't have authority, they have immunity. And so what the court found below, which I think is...
To have a discretionary, who conferred, can you just tell me who conferred or what conferred discretion on the Turkish security detail to operate on Americans as opposed to simply securing the president by not coming, by driving away, by rushing him in? What conferred authority on them to operate on American civilians in a way that the Secret Service could not?
I see I'm over my time, Your Honor. May I please respond?
Of course, yes.
Thank you. The authority it comes from the common law, the international law about the relations between sovereigns and its immunity. And so,
yeah, but immunity doesn't mean you're immune from the law. It means you're immune from the courts. Okay,
it means
you're immune from the courts. If the State Department said after viewing this video, get those people out of here and they may never return, They could do that, right?
Yes, ma'am.
And you would have to comply, Turkey would have to comply with that, correct?
Yes, Your Honor.
Okay, and so it's not as though that Turkey has a legally conferred by Congress or executive branch right to, say, commit violations of criminal laws in this country. It's simply that they won't be hailed into our courts, correct? That's what the immunity is.
Civil courts, Your Honor. I think the criminal court is an entirely different analysis. And what would happen here?
Okay, but I'm saying, so it's a right not to be hailed into our court. It doesn't mean the United States government couldn't demand reparations. It doesn't mean the United States government itself couldn't impose some sort of sanction or punishment or consequence, correct?
Correct. That's
okay. So you're not immune from the law. You're immune from the courts. Okay. So
correct.
So you can't. I'm having trouble understanding how the Foreign Sovereign Immunities Act is a source of law conferring legal discretion on the Turkish security detail to act on American civilians.
I don't believe that it is a source of law allowing them to act on American civilians.
What gives them this discretion? What is the source of their discretion?
The source of their discretion is the immunity that's conferred on them by statute.
Immunity is a consequence. It's what happened. You don't, unless you're telling me that there's a statute or regulation that says, do what you want, you have immunity, which is not what the FSIA says. It just says you can't be hailed into our courts. So what is it? Is there something international? I'm really quite bamboozled by this question.
Right, and I think, Your Honor, it goes to the discussion that the court was having with the appellees during their opportunity to discuss the case with you. What happens to Americans, it's international law, it's comedy. It's the discretion between nations. Your Honor has very accurately identified the other avenues that are available to plaintiffs to avail themselves.
Can you point me to an international law statute cases recognizing the authority of foreign security details, not to just secure their person by driving away, by not coming at all if there's a security risk, by rushing him into the building, but instead to reach out and attack local civilians? Maybe for good reasons, maybe for bad reasons.
And in that scenario, I would refer, Your Honor, to two things: the statute that we've been discussing and the Berkovitz test.
Which statute? Okay, the Berkovitz is simply a test for immunity from court. It's not a source of discretion. The discretion always comes from some other positive source of law. There's something else that confers discretion on our federal agencies to act. They have their organic statutes. That's what we do under the FTCA. And so what was the first statute you've been talking about? Is that
128?
18?
I'm sorry.
Is that, go ahead. Sorry. What's that?
And I'm sorry, Your Honor, it may be on my end. Some of the words I'm missing, Your Honor, said. The statute I'm referring to is the original statute we were discussing, 28 USC 1605, which talks about how you make the determination. Because I'm not aware of, and I'd be happy to brief. I know we haven't briefed this.
Immunities Act. We're back to saying the Foreign Sovereign Immunities Act is the source of positive law for It's just, I get your argument that if you meet discretionary function, what that statute says is you can't be held into our courts, at least civilly. I understand that.
Okay.
I'm not aware of any. I'd always thought there was some source of positive law that conferred discretion on governmental actors that we could look to, so we would know what the scope of the security detail, or security details generally, authority is in the United States.
And what I'd ask the court is perhaps that's something that we could do further briefing on, but my sense is it has to do with the treaties that go between nations for the protection of internationally protected people or internationally protected persons. So that's why I was referring us to the discussion Your Honor was having earlier about Judge Henderson's example of what happens to the Marines that rush out of the embassy to protect an American president in Istanbul, right? That's where that discretion comes from. We go to Istanbul, we Americans go to Istanbul, and our president and our Secret Service and our Marines, they're given discretion to protect our president. And so when the president of another nation like Turkey comes here, we involve them.
Is it true that the Marines can leave the embassy grounds? They're a military force. I thought if they left embassy grounds without authorization, they would be invading the other country. I'm not talking about Secret Service, I'm talking about the Marines at the embassy.
I only mentioned the Marines, Your Honor, because I think that was in Judge Henderson's
right, but
hypothetical.
I wouldn't assume lightly that our Marines can leave their location and go into the territory of a foreign country to attack people.
What happened in Benghazi? I thought Benghazi, when the locals were either nowhere around or completely failed to help.
The answer is I don't know that, Your Honor, as it relates to Marines. But to keep it more sort of in line with where we are with presidential security, if our presidential security, United States Secret Service or United States Department of State, which are tasked in many of the same regards as the Secret Service, were to rush out of our embassy or the residence and take the actions akin to this, we would, under international law, demand that discretion for their actions enable them to have the immunity that Turkey has here in this case. But Your Honor is absolutely correct that if there was a Turkish national who claimed that they were hurt in that or that they had been injured in some way and they had suffered a tort, there would be an opportunity for them, as Your Honor points out, through bilateral negotiations between countries, through other means. It's not in the civil courts.
No, but it sounded like you said earlier, I'm sorry, this is my last question, but it sounded like you said earlier that, and this would make perfect sense to me, that before a foreign dignitary arrives, there's negotiations between the United States government and the foreign government on what kind of security and security detail they bring with them and what their role is. But no one has put that in, what was arranged in advance. In this case, no one's put that into the record. And it seems to me that would be the likely source, would define sort of the metes and bounds of what the discretion is that the foreign security detail had, but that hasn't been put into the record.
I think in this record, Your Honor, I'd like to cite, if I may, to the joint appendix. The district court found, had the facts of these cases—
What page on the joint appendix?
It is JA 455, Your Honor. Had the facts of these cases differed slightly, the court's decision as to defendant Turkey's sovereign immunity may have differed as well. The Turkish security forces had the discretion to protect their president. And the court was correct in its initial threshold matter. It was correct in its Berkovitz Prong 1 analysis. And it was mostly there on the Prong 2 analysis. The problem is, the court erred by adding in this sort of violent acts or degree situation, where the court went on to say, the Turkish, and this is JA 455, the Turkish security forces had the discretion to protect their president, but they only had the discretion to err to some degree. And that absolutely captures the problem below with the district court, which is the district court is entering into exactly the type of second guessing that Gaubert said they cannot do. District courts, there's 700 of them across the country. Each district court cannot engage in an analysis of what is it excessive or not excessive? Is it abuse of discretion or not? Because the reality is, I don't know why I started talking louder, I apologize. The reality is that when we start down that road, we are bringing international relations to a screeching halt. There is nothing more susceptible to policy analysis than national security. There's nothing more important in a single sort of point to national security than the head of state and the protection of that head of state and what that means in international relations. And so the problem becomes Congress allows an abuse of discretion to be tolerated, but the district court erred and they thought it was just too much. And that's not what the statute says. The discretionary function, regardless of whether discretion be abused. That's the end of the analysis.
All right. Do you have any more questions, Judge Millett?
No. Thank you.
All right, Judge Wilkins?
No.
All right. Well, thank you, counsel, both. And your case is submitted.
Thank you very much, Your Honors.
Karen, can we take a 2-minute break before the next case?
Sure.
Is that okay, Ann?
Yes. This honorable court will now take a brief recess.
Anne?
Yes, Judge.
Good, you can hear me.
This honorable court is now again in session. Case number 20-1025 et al. Environmental Health Trust et al. Petitioners versus Federal Communications Commission and United States of America. Mr. McCullough for the petitioners, Ms. Boisel for the respondents.
Mr. McCullough, good morning. Please proceed.
Good morning. May it please the court. I'm W. Scott McCullough presenting argument on behalf of the 14 petitioners in these consolidated cases. One of the petitioners recently contacted the FCC to seek redress for injuries she attributes to RF exposures. The commission representative said, "We don't deal with humans, only frequencies," and hung up. That conversation encapsulates the FCC's approach here. By closing the inquiry, the commission failed its duty under the Communications Act to consider all potential health and safety impacts of radio frequency emissions on humans. It ignored over 1,000 peer-reviewed studies showing that exposure to non-thermal radiation at authorized levels evokes a clear biological response beyond mere tissue heating, and it leads to multiple forms of harm. It ignored direct human evidence of current injury. It failed to comply with the APA and NEPA for similar reasons. The commission has a substantive duty under the Act to have and maintain adequate emission limits beyond
Can I ask you a question about standard of review? You say that we shouldn't give the commission any heightened deference in this case, citing Fox Television, among other cases. But can you point me to any instance where we or the Supreme Court have not given heightened deference to an agency decision involving scientific judgments?
Well, there are various levels of discretion that are given to agencies, depending on the circumstances. This court and the Supreme Court has ruled that in the context of a petition for rulemaking, there is very high discretion. The problem here is this was not a petition for rulemaking. Indeed, if you look at what happened in the inquiry, the commission did engage in rulemaking functions. It established requirements. It extended its 1996 rules to situations, usage, and indeed even frequencies that were not covered by those. So it was functionally engaging in rulemaking here. And that's the level of deference that should be applied. But even under the highest level of deference, the commission still has to engage in reasoned decision-making. It still has to address all the material issues. It still has to respond to material comments. It has to look at the entire record and explain its reasons.
That sounds a lot like the standard from if we were reviewing after notice and comment rulemaking, whether they had sufficiently explained their final position and responded to substantial comments and concerns and addressed the record as a whole. What I'm struggling with is we're not at that stage. We're at the should they engage in rulemaking at all. And I understand your arguments about things that they didn't respond to with much of any sufficiency. But I'm searching for case law or precedent that says in this context, how much they have to say about contrary evidence in the record.
Well, my first point is that regardless, even if you are giving them the highest deference that is given under any circumstances, which we think they were engaging in rulemaking here.
Okay, let's assume I don't. Let's assume this for these purposes. We have a body of case law on petitions for rulemaking and how inaction or denial of those is treated. So within that body of case law, can you explain to me what our rule would be that they violated here?
This was not a petition for rulemaking. This was a proceeding.
I understand, but
the commission
I think that's the most analogous one for this stage.
And it was very much like in the Fox case, a notice of inquiry. And, in that case, this court did not give the highest level of deference. But no matter how much deference you give them, the problem here is you just simply cannot say that the 6 paragraphs the commission dedicated to addressing the inquiry can adequately deal with all of the evidence in this case. It did not mention all of the 1,000 peer-reviewed studies. It gave scant mention to only 3 items: the Rasmini, the NTP, and the bioinitiative. And it dismissed—
Which are the ones you sort of rely on most heavily, right?
Well, we rely on those, but we also very much rely on the underlying science and the studies that were used.
They don't have to address every submission. Can we agree on that? They don't have to respond to every—
They do not have to address every submission. They have to address every material submission. But
is
even
that
more
true? Is that true in this stage? Where have we said at this stage, as opposed to, again, at the end of notice and comment rulemaking, that they have to respond to every material submission?
We are not contending that the commission had to go by every single one of the 1,000 peer-reviewed
I said every material. You just said to me every material one. So now I'm asking you, where have we said that at this stage?
I think the Fox case— I apologize.
No.
I think the Fox case stands for that proposition. But no matter what scale of discretion—
And what, can you tell me which page on the Fox case you're relying on? I'm sorry, I didn't mean to hold you up.
Well, and I do apologize. Of course, the court addresses all of these things throughout the entire Fox case.
All right. If there's particular language or page you want us to focus on, maybe you could just tell us at rebuttal. I don't want to hold up your argument here. I'm sorry. I thought maybe you had something in particular in mind.
Well, I'll be happy to supply a post-submission on this. But, you know, the real and fundamental point here is that the commission does owe some duty substantively. It recognized that it had a duty when it opened the inquiry to give a full examination and explain its rationale and assure the public. In order to do that, it had to give some analysis to the evidence in this case. It did not mention a single one of these other studies. All that it did was mention the bioinitiative report and then dismiss it because it did not solve the problem of being able to also still provide service. It did not get into the underlying science that shows the level at which there are adverse impacts from exposure.
Can we talk about the role of the FDA here? Because the order said that no expert health agency expressed concern about the condition's radio frequency exposure limits, and that the FDA said no changes were warranted, in that Congress tasked the FDA with evaluating the health effects of radiation, and that's something that the FCC also argues in their brief. So what was wrong with the FCC relying on the FDA in this case?
It is permissible for an agency with jurisdiction to rely on agencies with expertise. But as was the case in the city of Boston, case, the agency with jurisdiction, when it looks to the agency with expertise, what that does is require the agency with expertise to itself explain its rationale and how it went about this. If you compare the FDA response here to the analysis that the court looked at in the city of Boston, you will find a magnificent difference. The problem also is the FDA was concerned, its letters, its short missives here looked only at cancer and only with cell phones. It did not look at all of the other adverse effects that the evidence shows occur here beyond just cancer. Finally, I do need to point out that the FDA is not necessarily the agency with expertise. The NTP study was contracted by the FDA. It looked to another agency within the Department of Health and Human Services, the NTP. Presumably, that's the agency with expertise. And so I think if you want to find the agency with expertise here, it would be the NTP. I will point out that the NIEHS, yet another DHHS agency, conducted a peer review of the NTP study, in which the criticisms, as short as they were, by the FDA were considered. And that peer review panel, conducted by the NIHCS, another sister agency, rejected the FDA's concerns and in fact elevated some of the things that were found in the NTP study. So,
Can I ask on the agency, the FCC here relied heavily on the FDA and its analysis because of their medical expertise. Have you ever had an opportunity? Did you have an opportunity? Is there any procedure by which you could either challenge the FDA or go to the FDA and prompt them to look at your medical evidence and change their position? It seems this is a very odd statute in that they have the technological role, but they don't have the medical knowledge, and you're asserting injuries that are medical injuries, physical injuries to bodies, in which the FDA seems to have more expertise. It almost seems like the one you should be talking to is the FDA. Have you talked to the FDA? Have you given submissions to them? Did they look at these types of reports?
There is no information in the agency record here on that point. There is information in the record where people near the end of this proceeding responded to what the FDA director said. But we do have a fascinating jurisdictional situation here. There is no direct way to challenge the FDA determination. But since the commission was relying so heavily on the FDA, I think what that means is you now need to look at the FDA letter and see what it addressed and whether the FDA letter reflects some kind of reasoned decision making. And we submit it does not. It is just as cursory as the FCC's 6 paragraphs here.
As I read the FDA submission, it was focused exclusively on cell phones and didn't address other devices.
It was exclusively on cell phones, and again, exclusively on cancer. It did not address some of the other NTP findings on other adverse biological effects. And I do need to point out that the commission's representation that all of the other sister agencies either did not object or agree, it is just belied by the record. The Interior Department has expressed concerns. The EPA has expressed concerns with the thermal-only approach. Obviously, the NIEHS doesn't agree. We have the Access Board findings. We have the CDC recognition of radiation sickness as a disease. It is just simply not correct to say that the federal government and all of its agencies is entirely aligned on this question.
But no one has proposed any specific change in standard, right? And you can't point to any international standard that is stricter or more restrictive than the U.S. standard. Am I correct on both of those statements?
There are some more restrictive standards, and there are some more all-encompassing standards.
What more restrictive standards did you cite in the brief?
Well, for example, I can certainly cite to the commission order itself, although it is not in the notice of inquiry. As the commission notes in paragraphs 122 through paragraphs 124, when it comes to some of the frequencies that the commission applied its regulations to, which were not in fact covered by the 1996 ones, specifically under 100 kilohertz and over 100 gigahertz. Some of the international standards are more restrictive, especially at the lower end of the band, than the commission's ones are here. If you take a look at, for example, and you may not have it in front of you, but note 328, when they're talking about neurostimular responses to low frequency emissions below 100 kilohertz. The commission actually recognizes the very symptoms that we recite for what we call radiation sickness. And the international organizations have made special provision for that. In the part of the notice of proposed rulemaking, the commission proposes to make some changes to its regulations to more or less align itself with these international regulations. But it did not do so here in the notice of inquiry. At present, under the rules, for purposes of these regulations and these frequencies where the commission had not heretofore applied its rules in 1996, these rules now apply as a result of the notice of inquiry. The commission did indeed extend its 1996 rules to activities, frequencies, technologies that were not addressed in the 1996 orders. And that is why we say this was functionally, although not in name, a rulemaking. It made new rules for all of these new things that were not contemplated in 1996.
I understand that argument, but what the FCC says is that basically in all of the comments, there's a lot of sound and fury, but there's no specific recommendation other than one, I guess, from the bioinitiative report that says set the limits, 1 million times more restrictive or 1 billion times more restrictive. And they say that the technology can't work if those levels are that low. I didn't see any rebuttal to that point. And the only rebuttal I saw in your brief and the reply was, well, the bioinitiative report suggested a path forward. Well, when I read that report, the path forward I see is, well, there needs to be more study done, but there's no specific regulatory limit change that it proposes. So do you disagree with anything that I've said there? And if not, why isn't that undermining your position?
I see that I'm somewhat over my opening time. May I still
go
respond?
ahead? Of course, go ahead.
The first step to solving a problem is recognizing that there is one. And the bioinitiative's main point was there are these significant aspects of the problem that the thermal-based rules do not address. And that is that there are biological responses that occur. There's biological responses, many of which are adverse, when you are exposed to authorized emissions. The bioinitiative said, based on its analysis of the studies, here is the point at which there is a response. The bioinitiative was not necessarily recommending that emission limits be taken immediately all the way down to the point where there is a biological response. Their main point was you need to adjust your rules so that they are biologically based, not thermal based. It then recommended collaboration between the scientists who understand biological responses, the commission, and those who design networks to try to find the point where you could have services with less harm. And so the bioinitiative was not saying take limits down all the way to this level. It was saying recognize there is a biological response and let's find a way to adjust standards so that we lessen the harm while still maintaining the ability to provide service.
How does that translate into error by the commission here?
It does, because what the commission demanded in the inquiry and in the order, it said, we're not going to pay attention to your science unless you also solve the service utility problem. And the entire point is there's two problems. The problem is the biological response. And then you have to figure out a way to address that within the context of being able to still provide service. This was a notice of inquiry, or at least it was supposed to be. In the actual rulemaking would be the time to find the actual emission levels that would serve both needs. And so the commission just completely misconstrued and misapplied what the bio initiative was saying. They were not saying take it down to this level.
Okay, can I just interrupt you for a second, because there's something that I thought was very interesting about the briefing here that I'm trying to get the take of both sides on. On page 37 of the FCC's brief, they refer to 21 USC section 360 II. As part of their argument that the FDA is really the kind of expert agency on human health impact of radiation of this sort. And that particular statute says that the FDA is supposed to kind of get this advice and expertise from a technical electronic product radiation safety standards committee, which is created a couple of sections later in 360 KK, subparagraph F. And that committee is supposed to have, of diverse representation of people from industry and scientists and medical professionals, et cetera, to basically kind of do what you're saying that should undertake the sort of analysis that you say should be done. It's interesting to me, though, that you don't reference this committee at all in your briefing. It's also significant to me that the FCC doesn't reference that technical electronic product radiation safety standards committee in their briefing, even though that committee is supposed to take the lead on testing things like cell phones and the testing standards and the standards that they're supposed to meet. Why is it that you don't seem to think that this statute has any relevance, or at least you don't talk about it in your briefing?
We do not talk about that in our briefing because it has no relevance to this proceeding. We are dealing with the Communications Act, which has given to the commission the exclusive right to set emission levels for all point sources. The FDA's jurisdiction over some radiation emitting devices is far more limited than that. And while it is true that the FDA itself would have jurisdiction to establish rules upon proper petition, that would be the secretary of the FDA, not necessarily the division that handles these that Dr. Shura is with. And so we have not only a procedural and jurisdictional problem, there's also just nobody seems to have invoked or sought a rulemaking from the FDA that would have set in process the committees and such like that are described in the statute you cite. We are dealing with the federal.
Does that committee exist or not?
I beg your pardon?
Does that FDA committee exist or not?
There is no evidence in the record on that as far as I know.
You just know whether it exists?
I do not know. I apologize. Remember, in this context, in looking at it from more or less a NEPA perspective, the commission is trying to rely on the FDA as an agency with expertise, where the commission is the agency with jurisdiction. And the problem is the FDA is not necessarily properly considered an agency with expertise under the environmental laws. It deals with human health, not the environment. And so, I truly do think that the commission needed to look to far more than and rely on far more than a couple of letters from an FDA director. And once you look at those letters to begin with, they simply do not pass any kind of muster for reasoned decision making if this is what the entire case turns on. It does not at all compare to what this court approved in the City of Boston case, to again cite that example.
All right. If there are no more questions, then we'll give you some time in reply. We'll hear from Ms. Boiselle.
Good morning. May it please the court. Ashley Boiselle for the Federal Communications Commission. As I think the panel recognizes, the FCC was not writing on a blank slate in this case. Instead, it was seeking scientific evidence and recommendations on the effectiveness of radio frequency emission limits that it adopted in 1996 and that have been upheld against judicial challenge twice before. As both this court and the Second Circuit have approved, in making this evaluation, the FCC reasonably relied on the views of federal agencies with primary jurisdiction in public health, as well as recognized standards bodies. The FCC relied on substantial evidence.
Yes, I mean, first of all, I guess I should back up. Do you know whether this committee that Judge Wilkins referenced within the FDA even exists and whether it has spoken on this issue?
I'm not familiar with the committee or what its status is.
Okay. So in the notice of inquiry, the FCC flagged that it wanted to get input, including from these expert federal agencies, sister agencies, information on what had changed since 1996, and that is the ubiquity of the devices, the different types of devices, the sheer volume of them, and intervening developments in analysis of medical consequences, and in both the introduction and then even in your final decision here in your second report in order, there's lots of discussion about how there's so many new devices and people are using multiple devices. They're using them, way more people are using them, and way more people are using them all the time or through extensive periods. This was even before the pandemic when we're now living on this stuff. But even before that, the amount of usage, the number of devices used often simultaneously, the age range of people who are using these and how long they're using them. That was all quite sensibly what the FCC asked for. The FDA came back and talked about cell phones and cancer. How was it reasonable for the FCC to rely so heavily on a response from the FDA that there's no indication relied on this specialized committee and did not address the very things you asked for information on: other devices, the use of multiple devices, and physical harms other than cancer? How was that reasonable, even with the super deference you get at this stage?
Well, first of all, we didn't rely exclusively on the FDA's representations about the state of the science. You're right that their statements spoke specifically about cell phones, although their public
rely on that at all.
Other than I think
it said about cell phones, but that just simply didn't answer the question asked. So how was it reasonable to rely on it? I don't want to hear. I just want to know how it was reasonable to rely on something that was not responsive to the inquiry.
Sure, for two reasons. One, cell phones are used in close proximity to the body, and the power of an emission decreases exponentially with distance. So cell phones are the device that is creating the most radio frequency emission when compared to other devices and other base facilities. Second, we have aggregate limits that apply to fixed facilities. Those are set forth at 1.1307B3, and they require that all
fixed facilities. I'm talking about watches. I'm talking about iPads. Okay, those are not fixed facilities. So
sure.
And then I'm also not talking about just using a phone and holding it up to your ear. People don't use their phones, hardly use them for phone calls anymore. They're constantly in the hand, not 2 centimeters away. They're constantly in the hand, and the fingers are constantly on them. And so I'm just trying to understand how the FDA coming back and talking about cell phones that are in a holster where nobody keeps them anymore, or are in a purse where they're not being used, is it all, and looking only at cancer, is it all relevant to an inquiry, again, into the effect of this radiation frequency from multiple devices that are used in entirely different ways now, in entirely different volume, and throughout the population, including children who live on iPads?
So as I said, the FDA said in its letter at JA 8187 that it was engaged in an ongoing review of the evidence in this area. And then, as you say, it represented a specific conclusion with respect to the National Toxicology Program's research on cell phones. But that was coupled with representations in our termination of the notice of inquiry at JA 12 that the World Health Organization had found no substantiated adverse effects from fixed facilities. So this wasn't an inquiry that was limited narrowly.
You are way more expert than me. Is an iPad a fixed facility?
No, an iPad is not a fixed facility.
Is a watch a fixed facility? No.
Right.
Okay. Is a wireless laptop a fixed facility?
No, but
when the notice of inquiry talked about the ubiquitous use of devices, was it talking about fixed facilities?
No, not exclusively, but I was going to
No, but I don't think that was okay. I get that, but
I apologize for not being responsive.
The fixed facility stuff, to me at least, doesn't feel responsive unless I'm misunderstanding it. I'm really curious about all these other devices.
Absolutely. So with respect to mobile and portable devices, we said at paragraph 143 of the notice of inquiry and paragraph 67 of the order on review here, that there didn't need to be aggregate limits, that we didn't have a concern about the aggregate effect of transmissions from these mobile and portable devices because they tend to be used.
I'm sorry.
It's okay. It's 67.
Are you talking JA 67 or 67?
It's paragraph 67.
Sorry.
It's JA 35 to 36.
Okay.
So we explained in that paragraph that exposure from mobile and portable devices tends to be a more localized exposure when they're held close to the body. That would cover things like a watch or a tablet held in the hand or a cell phone. And that exposure, because it's more localized, tends doesn't need to be aggregated because the whole body exposure is much more diffuse. So we addressed the fact that
and what other expert agency was the one that addressed that for you?
We were making that judgment in our own technical expertise that the effect of these emissions was not significant in the aggregate, and that therefore there didn't need to be any kind of aggregate limit. But with respect to our reliance, pardon me?
How did you decide? I mean, these things are strapped onto the arms and in the hands a significant part of the day. How was it that you decided that that was not a significant change from what you had looked at in 1996?
Well, there are no substantial adverse effects from exposures at the existing levels. So the fact that they're strapped on the wrist.
And how did you find that? Was this through your 2.5 centimeter test?
Well, no. What I'm doing is referring to our explanation of why the existing limits continue to be sufficient. And what we said in terminating the notice of inquiry is that the scientific evidence, and we relied on the FDA, but we also referred to other expert organizations and bodies, that the scientific consensus had not changed. And I think it's a mistake to characterize what we did as relying exclusively on the FDA's conclusions, because that's not what we did here. We also looked to the views of, as I said, the World Health Organization at JA 12, the International Commission on Non-Ionizing Radiation Protection, the National Toxicology Program scientists themselves said don't rely on this rat study and extrapolate to humans. So it was a broader inquiry, and we engaged more broadly with the experts in this area in drawing the conclusion that there were no substantiated adverse effects. And your question, I think,
I see what you're talking in some paragraph 66. You say that people worry about cumulative ones. Exposure from fixed RF sources will vary, but we're not talking about fixed RF sources. And so, where do you say for non-fixed ones? I'm not reading the paragraph. Maybe it's the way I'm not reading it with your expertise. I'm missing something. Where are you talking about non-fixed in paragraph 67?
We say that the location. Let's see. Sorry. When the RF sources are close to the body, they will be exposing smaller areas of the body. It's at the end of that paragraph. And separated sources will accordingly expose different areas of the body without overlap.
Yeah, that's just descriptive factually of what happened.
If you keep reading, so it's 67 leads into paragraph 68. We note that the exposure from each portable or mobile device near a person will generally involve low total power absorption while being highly localized and will not result in significant contributions to whole body average.
And what are you citing for that conclusion? I don't see any authority cited or any study or any explanation of how you came to that conclusion, other than that just conclusory statement. The footnote.
You're correct.
So
well, you're correct. How did we decide that the localized exposure would be absorbed in
multiple localized exposures for prolonged periods of time?
How that would not be harmful?
Yeah, how did you decide that?
Well, again, I think you have to link the observations here with the observations we made in concluding the notice of inquiry. You're correct. There is no footnote here, but if you go back to the resolution terminating the notice of inquiry, we said repeatedly that there was no evidence of any effect, not just cancer, any illness from radio frequency emissions below our existing levels. And in fact, we said below, at, and sometimes even above our existing
and
levels.
That one said, sorry, can you point me to that paragraph where it was addressing cumulative impacts?
Again, I apologize if I'm not being responsive to your question, but the cumulative effects are addressed here in addition to 1.1307.
And you're referring back to findings that were not themselves cumulative.
No, the scientific conclusions here are cumulative. The scientific studies that the FDA and others have looked at, and
no, the FDA didn't. The FDA was only talking about cell phones. That's my point. That's what there could well be. It's a very big record, and you know better than me. There could very well be something where it was clear that you were relying on either your own determinations rather than just conclusions, or there's another FDA somewhere else, or another agency talked about cumulative exposures from multiple devices over a prolonged period of time for physical impacts other than cancer. And is that, you're telling me that was made at the beginning, cumulative?
I don't know that we used the word cumulative in terminating the notice of inquiry, but the statements that we made.
That's what you meant. What paragraph are you talking about? Did the FDA ever talk about anything other than the cell phones?
In its public statements, it makes broader statements about the science.
I only talked about cell phones. That was the only science it had to back it up, right?
I think that most of the FDA statements were about cell phones. But again, those were supplemented by representations by other entities.
What other
the state of the science? Again, the World Health Organization, the International Commission for Non-Ionizing Radiation Protection, which also, pardon me?
Just to be clear, so, and they talk specifically about cumulative exposure from the use of multiple devices for prolonged periods of time. As you've noticed, this was the whole reason you had your notice of inquiry, these changes. And they talked about those specifically.
The studies that were conducted, or the scientific conclusions, reflect the conclusion that even the cumulative effects are not harmful to human health.
They're mobile devices, these wireless devices, not of fixed devices.
Yes, because the only substantiated harm is a thermal harm at this point in time. And what we know is that at 4 watts per kilogram, we start to observe thermal changes. There are no substantiated adverse effects below that level. And as it is, our standards incorporate a substantial safety margin. They're 50 times safer than that 4 watts per kilogram.
Only looking for thermal effects, but not looking for non-thermal effects, right?
We're not, the limits address both kinds of effects because the only substantiated adverse effects are thermal ones. And we acknowledged evidence on the other side. We acknowledged that much of the record was not scientific. That which purported to constitute research evidence lacked any persuasive case as to its value or significance. We acknowledged 3 of the 4 major studies that petitioners rely on in their brief and explained why they didn't provide any basis to reevaluate our limits. And again, going back to the panel's questions at the start of opposing counsel's presentation, the standard of review is quite high here. This is not the kind of case that presents the rarest or most compelling of circumstances in which reversal is required. We based our decision on substantial evidence, as the Second Circuit and Cellular Phone Task Force and this court in EMR Network held. It was reasonable for us to rely on.
Can I explain my problem? I'm just going to be very upfront with why I am inclined to rule against you. So I want you to tell me why I shouldn't have the concern that I do. So I misstated earlier when I said you referenced on page 37 of your brief, 21 USC 360 II. It was page 23 of your brief.
You said that.
And you say that Congress directed the FDA to establish an electronic product radiation control program designed to protect the public health and safety from electronic product radiation. The statute that you cite there is section, it's 21 USC section 360 II. When I read that, it says that basically the way that that is done is that a committee that is established in a cross-reference to 360 KK will be established that will review these standards for testing and emissions level. Okay? But you don't reference that committee anywhere, and I don't see anything about that committee mentioned in the administrative record. Then later on in your brief at page 37, you say not to worry because the FCC stands ready to consider changing exposure limits in appropriate circumstances. And you refer to a radio frequency interagency working group that maintains a continuing dialogue between the FCC and the FDA about these issues. And that's referred to in a letter. Or you say that it's referred to in a letter. But when I read that letter, I don't see any mention of that working group. And I don't see anything in the record that says that that working group actually exists or looked at any of the evidence in this case. So the problem that I have is that you say that you're relying on the expertise of the FDA, but the entity that Congress specifically said to review this committee, you've given us no evidence that this committee has looked at any of this. And then you say that in the future, to the extent anything needs to be looked at, it's going to be looked at by this working group. But I don't see any evidence that the working group looked at anything this time. So why shouldn't I send it back for the relevant working groups and the FDA to look at this record? Tell me why my vote shouldn't be to do that.
So with respect to the working group, it does exist and it is an ongoing project. With respect to the omission of any reference to this committee in the order terminating the notice of inquiry, we did formally solicit the views of all expert agencies in the notice of inquiry at JA 165. We made very clear that we intended to rely on them. We were very interested to hear their views, and the views that we received, we took into account. And I think that that's all that's required here. We explained why our conclusions were what they were based on the representations that we received.
Is there anything in the record that says that the FDA asked this radio frequency interagency work group to review this and they weighed in, or anything in the record that says that the technical standards, et cetera, committee that was created by statute reviewed any of this and weighed in?
There's nothing that says that specifically. Pardon me.
Is the answer no?
The answer is no on that specific question, but I would just point your attention to JA 8187, where the FDA says explicitly, they acknowledge 5G specifically, which goes to Judge Millett's questions about the proliferation and ubiquity of personal devices, but they say FDA is responsible for the collection and analysis of scientific information that may relate to the safety of cell phones and other electronic products.
So why shouldn't we as a court reviewing this say that at a minimum, FDA should tell FCC and by extension tell the public and any court reviewing this that the expert bodies within it reviewed the materials that were submitted in response to the notice of inquiry, i.e., if we want to say this interagency work group is the right body, or if we want to say that the committee that Congress required the FDA to establish is the right body. But one of them, why shouldn't we at a minimum say before we believe that we can allow kind of any sort of deference to the FCC relying on the FDA, we need to know that the right people at the FDA actually looked at the materials.
Well, I think that there's nothing in the statute that suggests that the committee has to speak through the committee. I think that the FDA, as the agency charged with keeping abreast of the science in this area, can speak to the state of the science. And it does refer to its ongoing monitoring activities in its letter to the FCC at J8187. And this is extra record material, and we're not relying on it for you to uphold the agency's decision, but the FDA did release a review of the scientific evidence in 2020, and its conclusions were consistent with the conclusions that the FCC drew here.
That.
No, we're not arguing.
We can't consider that.
That's absolutely right. And we're not suggesting that you need to consider it to uphold the agency's decision, but I think it does confirm the centrality of the FDA to this area.
The FDA, it's not just that we don't know that they asked their experts. We don't know what they asked them, because all we got from the FDA is cell phones and cancer. We know whether, is it reasonable for the FCC to take the FDA's representations at face value without verifying that the relevant experts have looked at the questions that the FCC actually asked when they get a report back that only talks about cell phones and cancer?
I think it is reasonable for the agency to do so. And I think that's what the Court and Cellular Phone Task Force said.
No, it didn't have to know. And in fact, I mean, in our case, we specifically noted that what could make a difference is if circumstances change. We have that in there. And that circumstances could change over time. Then there would need to be another look. And that was what you all flagged in your notice of inquiry was things have changed, including the ubiquity and multiplicity of devices. And then when the FCC gets an answer back that simply isn't answering those questions, and then as Judge Wilkins has pointed out, doesn't even say we consulted the people who are in charge of studying these things. That just seems to be, you get a lot of leash, but at some point that leash goes too far and becomes unreasonable without a little bit of follow-up by the FCC to verify, just to pin down that the information is responsive.
Well, I hear your concern again about the cumulative effects here, but I think the predicate question to any assessment of the cumulative effects is whether there's any adverse effect at all from a single device. And as I said, the only substantiated adverse effects are thermal, which would mean that cumulative effects wouldn't be something that could cause injury, at least under the substantiated credible scientific evidence as it stands now. And
how do I know that the radio frequency interagency work group doesn't believe that there are non-thermal effects that should be regulated? How do I know that the committee that Congress told the FDA to create, this Technical Electronic Product Radiation Safety Standards Committee, doesn't believe that there are non-thermal effects that need to be regulated or concerned? I mean, my point is that you're asking me to infer a negative but without there being anything in the record that the agency that Congress said should look at this, the committee that Congress said should look at this, even looked at it. And then you refer to an interagency work group that you say looks at these things, even though there's nothing in the record about that work group or what they looked at or haven't looked at.
Again, I think that we formally solicited the views of other entities with expertise in this area. We made very clear that we wanted to rely on them. We relied on the views of expert agencies in adopting these limits in the first place, and no federal agency or body. Did you solicit
these committees, or did you just solicit the FDA?
At JA 165 of the notice of inquiry, we said we formally seek the input of all of the expert bodies in this area. And we left the docket open for 7 years, giving ample opportunity to weigh in, and not one of these bodies said you need to change your standards. And we're not arguing that silence should be construed as endorsement, but it shouldn't be construed as disapproval of the agency's existing limits. I think even if you construe it as neutral, all of the representations that we did receive, and again, the FDA it's undisputed that
you
the
want
FDA
us to construe it as deliberation, that silence should be construed as these relevance committees actually deliberated, actually reviewed the record in studies. So you are asking us to infer something that's significant.
Well, all that we're asking you to infer is what the Second Circuit and Cellular Phone Task Force said was reasonable, which was for us to presume that the agencies and bodies charged with staying on top of this area and regulating in this area and paying attention to the science in this area have done so. And yes, we're asking that you presume that the agencies with responsibility in this area,
even when the report that they send back doesn't reference, lots of relevant studies and lots of relevant issues, we still presume that they reviewed those studies and those issues.
Yes, I think it's reasonable for the FCC to presume that they did. As I said, the FDA referred to its ongoing monitoring activities and confirmed its responsibility in this area. And I don't think that there's any requirement that the FCC wait for this committee to speak as a committee, that it can't rely on the FDA's representations about the state of the science. Again, this committee is created in the FDA's operating statute and appears in the section right after FDA has been anointed the agency with responsibility in this area. And under the
you can't tell me whether that committee even exists or whether the committee reviewed anything having to do with this petition.
I can't sitting here. I don't have any personal knowledge about that committee. I do know, as I said.
Why shouldn't that bother the court?
Well, again, because the FDA weighed in. It's statutorily directed to be the responsible agency in this area. And I think the FDA, we know it does have primary jurisdiction over public health. I don't know that every other member of that committee does, but they are certainly well equipped to evaluate the science and make a representation about the sufficiency of the radio frequency emission limits. I mean, one other point, the FDA regulates in this area. They are responsible for promulgating the radio frequency emission levels for devices that the FCC doesn't regulate. So again, this is an important part of their mandate. And just as we relied on expert agencies in adopting the limits, it was reasonable to do so here. Just one more point on this. As I said at the outset, we weren't writing on a blank slate here. In 1996, we adopted these limits and we had the input of the FDA, the EPA, OSHA, and IOSH. So these limits don't reflect the views exclusively of the FDA. It was a considered and lengthy deliberative rulemaking, and none of them weighed in to say that they needed to be changed. I'd be happy to answer other questions of the panel.
I do have one. How difficult would it be to determine whether these committees and working groups exist?
I can easily.
Well, I mean, are they set up by regulation or that's my question. Is it a question you can answer with some sort of supplemental submission?
Yes. It is a factual question, and it's certainly one that we can answer in a supplement if the panel is interested.
All right. All right, are there any more questions?
None for me.
All right, Judge Millett.
More.
If there are no further questions, we ask that the petitions for review be denied.
All right. Mr. McCulloch, why don't you take a couple minutes and reply?
Thank you. I'd like to try to make about 5 or 6 really quick points. First of all, to follow up from the questioning about Fox, if you could take a look at 780 F3rd at 1024 to 1047. That's where the court discusses the matter that we were addressing. You might also take a look at the American Horse decision that we cited in our brief. It says that even at the high level of deference, the agency has to explain.
I'm sorry, which pages in Fox specifically are you talking about?
1024 to 1047.
Wait, I have, sorry. Fox starts on 1027, doesn't it? I'm so sorry.
I may have that wrong. I was dealing with a printout, but it is in there, and I do apologize. I really do have to push back against the finding in the order in counsel's argument that there's no evidence of non-thermal harms. We don't have to go through it right now, but I would love to direct your attention to, when you get back in chambers, the exhibit that we distributed to the court for purposes of oral argument. There are 3 pictures in there, each of which show non-thermal impacts from radiation, blood-brain barrier damage, DNA damage, and then glucose metabolism responses. All of these are direct responses to and effects from exposure to non-thermal RF. So you just simply cannot say there is no evidence. All of this is in the record. The commission cannot say that there is no evidence when there are 1,000 peer-reviewed studies that show harmful effects from non-thermal. With regard to the agencies, the Interior Department, the EPA, the OSHA, a couple of them did respond to the commission in somewhat cursory fashion. Granted, you know what they said? They said, talk to the NTP. They didn't say talk to the FDA. They said talk to the NTP. They deemed the NTP to be the agency with expertise here. And we know what the NTP found. With regard to the RFIAWG, I cannot presently help you with the factual question you asked. We too would be happy to supplement. But I do know that there is evidence in the record indicating the RFIWG after 1996 supplied information to the commission expressing significant concerns about the non-thermal only approach. They too had concerns with the thermal only regime. With regard to Judge Wilkins' questioning about remand, we of course, that's precisely what we seek. We think the commission failed to address the record that was before it. It did not evaluate that information, and we of course would very much appreciate the ability to provide even more information because things happen every day. There have been developments since this order was issued a little over a year ago.
We can't look at developments after the record in this case.
I understand, and that's why we think that it should be considered on remand. As Judge Millett pointed out, the situation is far different now than in 2000 and 2004. In the science is far more robust. I was fascinated by the questions about cumulative impact and counsel's admission that when it comes to non-fixed sources, its rules do not account for cumulative impact, response to chronic exposures from any of these, much less mobile devices. And that is because they persist in this thermal only approach. But the evidence is clear that there are biological responses that are in many ways similar to what happens with thermal radiation. It is simply that it is an indirect response rather than a direct response. The same kind of health consequences occur. It just occurs indirectly through mechanisms like oxidative stress. Now, with regard to the contention that the consensus is the same, that is simply not true. Take a look at the chart on the right-hand side of our exhibit. The majority of studies now show that there are harmful thermal effects.
Are those charts that you submitted to us, are they part of the record?
It is a compilation of information that is in the record. They're not
from the record itself.
This particular exhibit is not in the record, but each of the squares is in, each of the images are in the record on the left and bottom side. And then the majority of studies chart comes from graphs that are also in the record. We just compiled. The commission insists there's no effect, but that is only because it insists on looking only at non-thermal effects. And that's the very problem here. When you are looking at the testing regime or anything else, yes, of course, you want to have a safety margin. When you're going around an obstacle, you want to give it a wide berth. The problem is the safety margin here. Everybody is so focused on the thermal effect that they're not paying attention to the ditch that you're driving into on the non-thermal effect side.
All right, you need to wrap it up, Mr. McCulloch.
Thank you. I'd be very much remiss if I did not make one final plea. The commission did not at all consider individual impacts for those who demonstrated that they are presently being harmed. It made no provision for them. It did not recognize them. These were individuals who have just had their lives devastated. We respectfully request that the court vacate and remand and require the commission to engage in reasoned decision-making and respond to all the material points and comments raised. Thank you.
All right, thank you. Ms. Boiselle, can you get whatever information there is about the formation of these committees and working groups we've been talking about and submit it? Well, let's say that should be fairly easy. It's either there or they either exist or they don't. Let's say by 5 o'clock tomorrow, and then Mr. McCulloch, let's see. I don't know that there'd be anything to respond to because they either exist or they don't, but why don't you take another 24 hours if you have anything you want to submit in response that is purely factual. And do my colleagues have anything they want to add or request?
Or just can we find out the timing, if possible, when they were created? Not only what exist, but when they came into existence.
Sure, that's a good point.
And if you're able to, the membership, who's on these committees?
All right. And Judge Wilkins, anything from you?
No.
About submissions? Okay.
No.
All right. Then I have one final question for Mr. McCulloch that has nothing to do with this case, but you practice law in one of the most colorful sounding towns I've ever heard. Where is Dripping Springs, Texas?
Dripping Springs, Texas is about 40 miles west of Austin, Texas.
Okay.
It is in the hill country, and it is a beautiful, beautiful small town.
All right. Well, I'm glad I learned of its existence. Thank you. All right. Your case is submitted.
This honorable court is now adjourned until Thursday, January 28th at 9:30 a.m.